Welcome to Idea to IPO. Hello, my name is Jennifer. Idea to IPO has been holding tech startup events in Silicon Valley for many, many years. We organize venture capital panels, legal workshops, networking events, and more. These days, we're mostly online. We hold an event nearly every day of the week. Please check out our schedule at idea2ipo.com. Our featured speaker today is Dr. Stephen Colby, one of the top intellectual property attorneys in Silicon Valley, and he is passionate about helping entrepreneurs succeed. Ladies and gentlemen, Dr. Stephen Colby. Dr. Colby, take it away.
Thank you, Jennifer. All right. Welcome, folks. I'm going to bring up some slides here. Boom. Okay. There you go. So as Jennifer said, we're going to talk today about how to avoid an intellectual property disaster. And my presentation is going to be primarily directed at people who are developing startups, who are looking for raising money, want to start a new business, maybe get some VC funding, and then have a beautiful exit and retire to a wonderful place, right? Is that you? Well, then this is the right seminar for you. Okay, so as Jennifer said, I'm an intellectual property attorney based in Lake Tahoe and Silicon Valley. I spend a good deal of my time working with early stage startups, which is my favorite. I spent most of the 90s as a CTO of a instrument company, and I have been the CEO of two mildly successful funded companies. All right. Currently, I am a partner at Ramon Law. Ramon Law is a semi-virtual law firm, always has been, and it's really nice because it is distributed around the world. We have about 185 attorneys and offices throughout the United States and Asia and Europe and Africa. Anyway, before I start, one more little disclaimer. Listening to this seminar doesn't create an attorney-client agreement between us, and I am not automatically your representative. The advice that I'm going to give is meant to be general and may not apply to your specific circumstances. All right? So let's get on with this. How to avoid an intellectual property disaster. So what I'm going to do is tell you about things to prevent you from making mistakes, right? There is a lot of reasons why intellectual property can be really useful to you, to your company. Number one, it can make your company more valuable and make your pockets, help line your pockets, make you richer. But there's also mistakes that can be made, and what you don't know can hurt you. Let's talk a little bit about these mistakes. All right, the dark side of intellectual property. So I know that if you're a founder or a CEO, you're juggling thousands of things at once. You've always got stuff on your plate, and your to-do list is at least 60 years long, right? So I'm going to go through a list here of things that I want you to specifically pay attention to for yourself and your company. And if our time is spent wisely here this afternoon, it will be very much worth it for you, okay? So let's look at the mistakes that I see most commonly in intellectual property, okay? The first two are ownership, and ownership is there for a reason. Ownership is absolutely both number one and number two reason that relating to intellectual property that startups can get in trouble, okay? The first deals with making sure you own your own IP, and the second is making sure you don't use IP owned by others. Okay. The third big mistake is waiting, not paying attention to your IP portfolio until it's too late. Okay, you want to file sooner rather than later. Very often I'll get founders of a company and they'll come to me before they pitch, right? Before they talk about anything publicly. While they're still in complete stealth mode, they'll get some initial filings done. And that's really helpful. It gives them early filing dates. It lets them answer the question when an investor says to them, what about IP? Then they can say, yes, we're on top of that. And they sound much more professional. Number four mistake is no strategy, right? There you can spend an awful lot of money, and I have seen companies do this, burn through a huge amount of money trying to file patent applications all over the world, and with a really not a very cost-effective approach, right? So we're going to talk a little bit about the cost and the budget and how you can start your IP portfolio in a bootstrap type scenario. The fifth thing that I want to talk about is understanding the patent. Okay, and what does it really mean? What does each of the types of IP that you get, not just patents, but copyrights and trademarks, what do they really represent? And you're going to be making decisions about what to do, what file, what's important for your company. And if you don't really understand what the final product is or how it works, then that's not really good. You need to be educated by your patent attorney on how to interpret these documents, right? So I actually give a whole separate seminar on understanding the patent, and Rob will probably have another one coming up in the next few months. But look out for that. I've done it before, and it's available on YouTube. So now let's go through one by one these mistakes that are so common. Okay, the first one: ownership. Owning your own IP. In the US and in most of the world, ownership usually vests, meaning it's owned by the inventors, not necessarily the company. Even if you're paying somebody, if they invent something, that doesn't automatically make the IP, whether it's a copyright or a trademark or an invention that's covered by a patent application, that doesn't automatically mean that the company owns it. So here's number one, write down this. Make sure that you own all your own IP, right? Every person involved in the company, to the extent you can, should have an agreement that has some type of IP clause in it, right? For founders, that should say, yes, I, founder, am I agree to donate my inventions to the company in exchange for the shares that I'm getting as compensation. All the founders agree to do that, right? For employees, there's an employee agreement that has an IP clause in it, okay? For contractors and advisors, you'll have different types of IP clauses. Clearly, if you're hiring a software studio to write software for you, they're going to be much more restrictive about what they're willing to give you, right? They will only give you IP over specific projects that they work on for you, not everything they do, right? Because they have lots of customers. So the language of these assignment ownership clauses are going to be varied depending on the class of person. Let me give you an example of why this is important. We all use Adobe, right? It's a lot of fun and it's really useful. It's ubiquitous on the web. And a lot of us use Adobe Forms, right? My kids' schools, they send us forms to fill out and it's an Adobe form. Okay, a really cool attribute of Adobe. That was invented by a sales guy at Adobe, right? So everybody that's involved in your company that you should have a clause in their employment agreement or contractor agreement that says, okay, I agree to assign this invention to the company. The actual language of the clause can vary a lot, right? Florida's laws and California's laws in the United States are different. It's a state by state deal. So in Florida, a company can have a much broader assignment clause saying, hey, everybody, any invention you make is owned by the company. In California, and I'm a California attorney, not a Florida attorney. In California, there has to be a nexus between the employee and the reason for employment and the invention. So if you're a software company and your employee invents a new non-software related lawnmower, the company doesn't get it in California. In other places, they might, depending on the specific language of the agreement. So you have to be aware of where your employees are and where they're working, right? So if you have an employee that's spending summers in Canada and winters in the United States, then you're going to worry about, okay, this person has, are they a Canadian employee or are they an American employee? How long do they spend in Canada, right? 89 days every year. So this is the types of things you need to worry about. And this will impact not only your HR, generally, you pay Canadian taxes or US taxes, but also things like assignments, right? There's an assignment process. So just like when you buy and sell a home, there's a recording system where the records of who owns what type of IP or patents, for patent applications and patents, is a publicly available database, right? So you can go to the USPTO, the US Patent and Trademark Office, and look at the assignment records and see who in particular at any one time owns a patent or patent application. And that recording is the supposedly last word on who has ownership, okay? So even if somebody has a employee agreement that says, oh, I agree to sign all my inventions to the company, when you have an actual invention and you file a patent application, it's also not absolutely necessary, but very, very nice if you have a separate assignment document specifying that particular invention, okay? That removes a lot of ambiguity, right? So make sure that after you file any type of patent application, you immediately turn around and have the employees sign that and turn it over to the country. What I'm talking about now is really a US law. It varies widely around the world, okay? So if you're in Spain, it might be that there's more of a presumption that something invented by an employee is owned by the company, right? There's not an automatic assignment. Ownership doesn't necessarily automatically start with the inventor. So you need to talk to, or you're a patent attorney, you need to talk to people in every country in which you have inventors, right? Make sure that that's done right, okay? So that's it. Make sure that you have assignment agreements, including the founders, right? If there's more than one of you, you'll want to have an assignment agreement that signs stuff to the company, and you want to make sure that gets signed, executed, right? I have seen cases where companies are 3 or 4 years old, and people, investors have put like $10 million into the company, and then there's like this, oh, the CTO never signed that paper, okay? And the CTO says, yeah, I'll sign it, don't worry, but I want 30% of the company. And I'm telling you, this is a true case, right, that I've seen. And boom, $10 million worth of investment, the company crashes and burns, there's no agreement, everybody goes their separate ways. That's an example of somebody who didn't get the assignments done like they need to. So put this on top of your list, right? You got to make sure you own your own IP and all the assignment documents get executed, okay? Don't let things fall off the edge of the table, all right? So that's owning your own IP. Hold on. All right, so number 2 in the big mistakes you can make is other people's IP, right? There's kind of a debate about, do you want to know about other people's IP? And specifically, I'm talking about patents here, right? So if you're a big company, if you're AMD or Intel, you don't really want your employees going and searching the patent databases. The reason for that is that if they learn about a patent and realize, oh my gosh, we're infringing this, then the liability for the company goes up. Okay, so big companies discourage their employees from searching for patents and seeing what the competition does, right? In my opinion, and other people may disagree, the startup viewpoint is very different, right? And I've worked with a lot of small companies and startups. I tell people, read the literature, and this comes from my scientific background, right? So go in and pay attention to everything you can, learn everything you can about your competition, right? And you have competition, right? If you don't, there's somebody at the fringes of what you're doing. I mean, I assure you. Find out where that edge is. Look at what other companies are doing, right? Including reading IP, the patent portfolios. It can give you a big advantage. When I was a scientist, reading the literature was something we had to regularly do to keep up on what other people were doing, right? The last thing you want to do is reproduce something that somebody else has already done and waste your time, right? Same goes for you as a startup, okay? Keep an eye on your competition, what they're doing. You should have a list of the competitors, first of all, and then their key people. Who are their inventors? Who are the people that are doing the development of these companies, okay? And keep an eye on their inventions. And if you read their patents, there's a bunch of things that can happen. You can say, oh, right, they've got a patent application on exactly, or a patent, right, which is a lot different, on exactly what we're doing. How in the heck are we going to do this, right? Or you could say, oh, they're doing something similar, but they're not doing it quite right. If they knew what I knew, they'd even be better. So boom, now you have an improvement on your competitor's IP, right? You're going to file for that, right? You're going to file your own patent application that stomps on the next step in their product development, right? So read the literature, write down your ideas, keep notes on what you read, do a thorough job of understanding what other people are doing. The big advantage that you have over the Intels and AMDs and Googles of the world is that you're an early stage startup and you're flexible, right? Intel has their product pipeline destined. They know exactly where they're going to be in a few years, right? It's just a matter of, we have this path, this roadmap that we've established, and this is where we're going. You as a startup can change direction. If you find out that some other company has already tried what you're doing, and then you'll research why they just failed or why they're successful, you'll learn a lot, right? But you'll also be able to go, oh my gosh, there's IP all over this place. Let's see if we can license it. If we can't license it, let's turn and do something else, right? Let's redesign our product to avoid somebody else's IP. Since you're an early stage startup, you can do that, right? If you're Intel, it's really hard to do a redesign based on other people's IP. It's a problem, okay? So from the startup viewpoint, it's, in my opinion, much better to know everything about what your competition is doing. And this includes what they're filing in terms of patents. So read it, learn from it, improve on it, and if you need to, talk to your IP attorney about how you can engineer around it, right? Okay. Keep good records, okay? And the best CEOs that I work with, when they come to a meeting, they have a notebook, right? If you are watching this webinar and you have a window open where you're actually typing notes in at the same time, wonderful. That's exactly what you want to be doing. Bring a notebook, get a bound notebook, right? And just like a lab notebook from college, right? It's every time you go to a meeting, write down what people talked about, who came up with different ideas, etc. I'm going to give you an example. Let's see. Let's say you're having a meeting and you're a company that does self-driving vehicles for the sidewalk to deliver food, right? And you come up with a bunch of cool ideas about how to avoid dog poop. Sorry, skin of my mind, okay? Right, so you come up with these ideas, and then you have a meeting about it, you discuss it, you decide where on your product pipeline that's going to go, what version that idea might be in. 2 months later, you hire Susan from a competitor, right? And Susan comes in, and 2 months later, you've got this new feature, important feature in your application, and you're sued by Susan's former employee for trade secret misappropriation, right? Because they say, oh, Susan must have given you our poo-poo idea, right? So we're going to sue you, and it's going to cost you millions of dollars to fight this, and you're probably going to die as a company because of it, right? I mean, you don't have the money to spend hundreds of thousands on a legal suit. Well, it's a good thing you have a really good set of notes, because you regularly keep notes, and you can show that 2 months before you hired Susan, you had gone through this idea and it was well established and she wasn't involved in it, right? I mean, this is just one example of why you might want to take notes at every time you have a meeting. It's really useful from the IP standpoint. It's a good business practice. If you bring something up in a meeting, somebody else has some idea, you can say, hey, we talked about this ages ago, blah, 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 right? I always have, when I'm on a Zoom meeting, I have a window open, as I'm the one doing talking, I have a window open and I'm taking notes, and I use Microsoft OneNotes. I store that, I put keywords in it, I might make it searchable, so that later, for a particular client, I can say, did we talk about this? Sure enough, boom, I can pull my notes out. Even if it's a networking event, I will take notes on people, right? I'll meet somebody and write down what they do and where they're located and what what features they might. And if I need a divorce attorney or a real estate agent in Boise, Idaho, I might have that in my notes. Okay, so keep notes. It's good. There have been a few times in my career where good records have made a huge difference. Emails that are 5 or 6 years old all of a sudden show invention. This can really make a big difference. And I actually have a place where I store documents electronically. That's kind of my archive. And so if I want to go find my 2004 taxes, I can find them. And it's all now electronic, of course. Right? The last thing we want to talk about with regard to other people's IP is open source. Open source can be really useful. It can save you a lot of money and time, right? Especially if it's something major like standard neural network software or an open source blockchain utility. That's critical, and it's going to save your company months of man hours to not have to reproduce. If you use open source materials, you have to read the license agreement really carefully, because some open source materials require that you yourself make anything that you've used those materials in also open source, right? There was a former president recently who was starting a social network, and they used a piece of open source software, and when they were about to launch, the owner of that open source software said, yes, please, you now have 30 days to publish your entire code base. And they had to pull the product and rewrite it all from scratch, right? Very embarrassing, not having the right attorneys around them, okay? So make sure that if a employee uses open source materials, that they tell you, and you have an attorney read the open source license, okay? The other thing you, of course, have to tell employees is don't ever bring code from your previous employer, right? Or any other type of IP. It's really tempting for an engineer to say, I did this for somebody else, blah, blah, blah. 2 years ago, and I'm just going to grab that 5 weeks worth of work, drop it in, and go on vacation because I've already done this. I'm not going to reproduce it for the new employee. Okay. Well, that's going to be a copyright violation somewhere. You're going to get caught in that, and it could kill the company. So you need to, in all your employment agreements, this should be worded. There should be paragraphs, and you should go over it with the employee. Don't take stuff from your, previous employer. Everything has to be clean with it, the new company. Okay. So that's all about other people's IP. Moving on. When do you start? Okay. Yesterday. Think of the Beatles, right? It is really helpful to get your IP started as soon as possible, right? One reason is that you will get earlier filing dates, right? If you're in a really competitive area and you're making some great strides forward in terms of development or implementing new ideas or new technology, you want to get those filing dates as soon as possible, right? I very often talk to people starting off, really two people and half a napkin, right? Filled out ideas. That's where I like to have new clients come in, right? And that lets us talk about strategy, which is next, and about getting early filing dates, because you want to get some early filing dates. In a few minutes, we'll talk about how to do that without spending lots of money, right? There's things called provisional patent applications, which are relatively informal, right? Which means it can include like a slide deck, a requirements document, a preprint of a scientific paper that hasn't been published. That type of thing can be part of your initial provisional patent application. And for whatever material you have in there, you get credit for, okay? So file these, they're really inexpensive, okay, compared to a full patent application. File these early, and you will get some good early filing dates. One of the other things that happens with early stage startups is changing direction, right? The idea that you have when you first meet your co-founders, right, or first meet your IP attorney might be different. The company might have turned 90 degrees in 6 months and be going off in a different direction. And so having spent a small amount of money on a provisional application is a lot easier to swallow than having prepared a non-provisional full patent application that costs a lot more money. So file provisionals early, file them often. Every time you develop a new feature or something, you come up with some new ideas, there should be another provisional filing, okay? So that's it, start early. Okay, let's talk a little about strategy. And so this kind of brings out, you know, as a former CTO, I'm really a product manager at heart, okay? I like developing products. I like selling on trade show floors. I can pitch software or hardware or all kinds of stuff. It is important. So the thing to do with IP is you want to develop IP that adds value to your company, okay? So you want IP that is really good for the marketing and sales team, right? So they can go to a customer or prospect and say, we're the only ones who have this, and you really got to buy our product because of this, right? Those are the things that help sell the product. That's what you want covered in IP and patents and other types of IP, right? So it should be a product-driven process. If you have an 18-month roadmap of where your technology and your development's going to be, right? Look along that roadmap and identify the things that are going to make the company sell, all right? And focus on the valuation of the company. And in the next slide, we're going to talk a little bit about that valuation bit, but it should be product driven. I don't want necessarily the things that the engineer think was so cool. I want the thing that's the marketing and sales guy says, oh my God, if we have that, we can sell everything, right? We're going to be fantastic, right? So I'm going to give you an example now, which I do for some of my clients. And we do slides, which is kind of a cluster, what I call a cluster map. I didn't invent this. And we take the 3 or 4 things that really make a difference in the product that are going to sell the product. So typically, if you're preparing a pitch deck right now, you're going to have a few points that you're going to tell investors. We are going to be the next unicorn and super successful because of A, B, C, and D. These 4 things, right? You want to patent those features. And it might be what you do is you look at those 4 features and say, okay, what's the technology that enables that? Those are the things we want to have on our patent application, right? Okay, so that's product driven. So what we'll do is I'll make a slide when the company's about at their A round, and we'll have a bubble showing a slide that has bubbles showing each of those 4 features, these 4 silver bullets that make the company really valuable. And then in other bubbles around the side, I'll have all the patents and patent applications. And I'll draw lines between them, making a big mesh, a big spider web. And that spider web is called a cluster map. It shows the relationship between the things that make the company really valuable and the intellectual property, okay? This is designed to make IP more than just a checkbox, okay? The IP should be more than just a checkbox, right? So that's how we get value out of the intellectual property, right? So why are we doing this, right? Again, it's valuation. Sometimes I see pitch events where founders are asked a question, well, what about your competition? And the founder will respond, well, we have a provisional patent application filed, so we don't need to worry about the competition. Well, that's the wrong answer, right? By the time your provisional application turns into a patent, it'll be a few years down the line. And then if you're going to try to enforce that patent, that might, you know, at a minimum be $500,000, more typically a couple of $1 million to enforce, to go through a full patent application, full patent litigation. You don't want that. That is not a good use of your investors' funds. It's not a good use of your time. Companies that I see having to go that route that end up in patent litigation as an early stage startup, they turn into basically patent enforcement companies because they can't afford the time or money to do anything else but that. The goal of the IP, my job for your company, is to increase the valuation of the company. Every time you raise money, right, I want the IP to support your valuation and to pay for itself many times over. in particular on exits, okay? When you exit the company, you sell to the big company, you sell to Google, Facebook, Samsung, whatever your target exit is. I want them to have paid significantly more for your company because you had a great IP portfolio, right? So the idea of filing patents for a company that's an early stage startup that's going to take investment from VCs and the like, the point of doing IP for them is to increase the value of the company. And I have seen cases where this has been really dramatic, where a big acquirer was looking at 3 or 4 companies that they were considering acquiring, and they went after and bought the one that had the best IP portfolio. There were other differences. Okay, the CEO was much nicer and easier to work with, and a much more valuable person than the CEO of the other company is. But it was hundreds of millions of dollars, right? And the IP made a difference. The other companies, they just folded, right? There was only one acquisition and that was it, okay? And so the IP portfolio can make a huge difference. If a big acquirer is, and I've seen this as well, if a big acquirer is looking at you, they will run a spreadsheet. They will say, how much is it going to cost us just to copy everything, duplicate what this company has done? We can put 100 engineers on it and have it done in 6 months, right? We just roll right over them, okay? Or should we pay all this money for them, right? And the IP makes a big difference in there, right? Because if they just try to roll over you, boom, they might get caught in a big IP litigation and all this headache. So, and I have seen this happen, right? Where a company with a startup with 40 employees, Microsoft, I'll name them, does a complete, after 6 months of discussions, right? Ghosts them, and then 2 weeks later comes out with a directly competing product, right? So that company turned into an IP enforcement company. They got money, right? They licensed to everybody, but it wasn't the exit they were looking for. It wasn't the value of the exit they were looking for. So circling back to the reason for this is IP can make you richer. That's it. Okay, that's why you want to do patents at this stage. Right? Okay, we've talked a lot about this. Why as a startup would you want to put all this money, right? You're the little guy, that little white blob here on the screen, okay? And you want to be good friends with the big one because they're going to buy you for $250 million, right? So what, the goal of my job is to make sure you're not just lunch, okay? Which is what's going to happen in this scene, I think. No, I guess not. But it looks like it's going to happen in this scene, right? So the reason that you're going to spend money on IP is to protect the value of your company, right? Hold on. Okay, we'll talk a little bit about the costs in a minute. All right, I promise to do that. Right? We've been talking about IP now, so like what IP can you get, right? Where there's patents, there's trade secrets, trademarks, and copyright. There are other types of IP, right? But these are the ones most common in early stage startups. Copyright covers like the writing or a picture or a painting, right? Or the words of a story, okay? So that's the actual implementation, the writing, okay? Or the artwork, right? A copyright could cover a web page, this layout, or a logo, okay? Trademark is meant to represent your goods and services, okay? So the product, not necessarily the company, but the product you're selling or the service you're providing, right? That's what a trademark is for. So a logo could be covered by copyright, and it also could be used as a trademark, all right? Trade secrets, depending on the type of company you have, trade secrets could be your #1 intellectual property. I'm going to say the most important thing I can say about trade secrets is document them, right? Write them down, have a list, get your company board together, have a meeting just to discuss trade secrets, and have a program saying, these are the things that we consider our trade secrets. Some trained machine learning system, all the coefficients are a trade secret. Your customer list, your pricing model, all these types of things, who you pay, what, right? All these things are considered trade secrets that you want to keep away, that have value to the company. They're more valuable when you actually write them down and document them, right? So you have a binder that you keep with your other important corporate papers, where you have a one-page description of every trade secret. You have a program that when somebody gets access to that trade secret, they sign a separate document saying, I understand this, the coefficients on our neural network and our training system is a trade secret of this company. I agree to never disclose this, blah, blah, right? So do that, have that program in place, because if somebody takes one of your trade secrets, right, and you try to sue them, you try to stop them from using it, their best defense is, oh, that wasn't a trade secret. Everybody knew it. The sales guys on the trade show floor talked about this all the time. I saw it in a presentation in some seminar somewhere, blah, 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 right? So, you want to actually have a program in place and keep records of what you think your trade secrets are and what, right? And have a program. So when an employee leaves at the exit interview, you say, these are the trade secrets. I'm going to remind you, you were given access to 3 trade secrets. You can't use those again, right? You got to try to reinforce that with the people who are leaving, okay? So trade secrets can be really valuable. The value of trade secrets goes up by an order of magnitude once you document them. And we're talking about a few hours of time, right? And it could be, I have companies that are in image processing, for example, where their biggest assets are their huge data training set, high quality training set. That's a huge asset, okay? And trade secrets they use where they've trained AIs to do image processing, right? Those algorithms and those neural networks are a trade secret of the company, which is not covered by patent, right? And it's hugely valuable. The final thing we're going to talk about is patents, and I'm going to talk a little bit more about that because I'm a patent attorney, right? I'm the type of patent attorney who's called a patent prosecutor. And that means I write patents and get them through the Patent and Trademark Office, okay? Let's talk a little bit more about patents. These are the common types of patents you can get, okay? A provisional patent application, that's not a patent, it's an application, okay? A non-provisional patent application. A non-provisional patent application is what actually turns into a utility patent, okay? And there's also design patents, design patent applications. So designs, applications, and patents are directed at the ornamental parts of something, like a hubcap, right? A cool looking hubcap for a car, that's ornamental, mostly not functional. They only last 14 years. The cost of filing them is mostly doing some really high quality drawings. My favorite design patent was by Logitech, the shape of their triangular speakerphone. I like this example because usually when I'm talking with clients in the old days, they'd be in a conference room and there would be a speakerphone in front of us. And I could point to the speakerphone and say, hey, that thing was covered by a bunch of patents on the electronics. But it turned out that the design application on the triangular shape of the phone was one of the most valuable patents that Logitech had, and they litigated it. They used that patent a lot. That was actually really nice because that look is so much nicer than a 4-pointed star or a round saucer thing. Like, so that design patent actually made a big difference to Logitech. That helped the company quite a bit. Design applications are only good for 14 years, right? Okay, jumping back. Provisionals. Quick and dirty, inexpensive. They're designed as a placeholder to get some initial filing dates. They're inexpensive and they're only good for 1 year. The 1 year after filing, they go away. You have to reference them and file a non-provisional application within that year, citing and claiming benefit of the provisional. If you don't do that, the provisional application goes away as if it was never done, okay? Because it's inexpensive and kind of informal, right? It also can have a lot of problems. Usually a provisional might be 5 pages where the full non-provisional application is 30 to 40. You can imagine there's not a lot of stuff that's missing out of the provisional. So very often we have to worry about, was that provisional really enough? I'll give a specific example. If you have a provisional application that includes your slide deck and just your very rough initial design documents for your software product, right? That probably leaves out an awful lot of detail. Okay, it says these are what we're going to do, these are these things, but it doesn't give enough detail to really support the full disclosure that you need in a patent, right? So if you file a thin, weak provisional, it protects you in terms of, oh, we filed before we had our public presentation, right? Everything that was in our public presentation had already been given a filing date and filed with the USPTO, right? So that means that you filed first, which is really useful, okay? But it doesn't give you enough because of protection in terms of, oh, we're going to get a great patent out of this, because it doesn't have enough disclosure in it, right? So there's kind of a balance there, and the more work that goes into provisional, the more expensive it is, okay? It's the non-provisional patent application that, after a back and forth process at the patent office, will give you a patent, okay? This costs a lot more, and we'll talk about costs in a minute. The patent lasts 20 years from the filing date of the non-provisional application, okay? So that is what actually turns into patents. And as we'll talk about, well, non-provisional patent applications can form families that can be related to each other. In other words, you can have an initial application and then in the US add some more material to it and have a daughter application, right? And they can build on each other. And as a startup grows over their first 5 or 6 years, they may develop a whole family, a dozen different patents and patent applications that cover a lot of aspects of their technology and make it, what you would call a strong patent portfolio, okay? All right, next question. A question I get a lot from people is, will I rule the world with my patents? So we've been focusing mainly on the US here. Outside the US, patents are by country, okay? So if I have a US patent, it's enforceable in the US. If I have a Canadian patent, it's enforceable in Canada, right? There are some group patent offices like the EPO, the European Patent Office, which provide you an advantage in that if you file an application there, it gets examined at that one office. And if it's allowed, sorry, then you can have a patent in any one of the countries of the European Patent Organization, European Patent Office. So you might go through and fight in Europe and get a allowance on a patent application, and then you have to say, okay, I want the Netherlands, Switzerland, Germany, France, and the UK, right? And you get individual country patents there, right? The only companies that really do worldwide patenting is pharmaceutical companies, right? You will look at what are my biggest markets, okay, where are my competitors located, and who's likely to acquire me? What's my exit, right? So if you think you're going to be bought by Nissan, you'll be sure to include a patent application in Japan. If you think it's Samsung's going to buy you, or Siemens, then you're going to go South Korea or Germany, right? So where you file, you typically an early stage startup, because these are really expensive, because there's more attorneys and lots of fees involved, you'll probably only file in a few countries around the world, okay? And then because those countries are the main markets, that will be the IP protection you get. You will not have the Philippines, likely, okay? You may decide yes to China and no to India for some reason, right? Patents are more enforceable in China than they are in India, but that's of course all relative, okay? So your patent attorney can sit down with you after you file your first application. You have a year to think about where you're going to file elsewhere in the world. There's something called a PCT application, which stands for Patent Cooperation Treaty. And that's basically an 18 to 19 month option to do more filings in different countries, right? So if you file a provisional a year later, you may file a US non-provisional application and a PCT application, both of which claim benefit of that provisional application, right? And 18 months later, you may go into the EPO and South Korea. This is all much too much stuff to talk about in a seminar like this, but your patent attorney can walk you through it at the time. So now my next slide, I'm going to talk about costs, right? So I am based in Reno. I'm associated with Ramon's office in Truckee. It's in Tahoe, and we have great snow here right now. I'm also associated with our Menlo Park office in Silicon Valley. I spend a lot of time in San Francisco. I visit there on a regular basis. And so the clients that I work with are pretty much all over the world. Asia, South America, Africa, Europe, definitely. I just got a company, a new client from Kazakhstan, right? I specialize in companies that are likely to get funding, right? Who want to do this model of, we're going to do a startup, right? Not a plumbing company or a company that's making a new food processor. Well, maybe a food processor. There was one time in my career where I had 3 ice cream companies that I was doing work for, making ice cream, right? So the question is, how much does this cost? So for a company, I'm going to show you actual numbers, which most attorneys won't do. And this is kind of a ballpark. Your experience is certainly going to vary, right? But I want to just give you an idea of kind of what the costs kind of you can expect. All right. So a provisional application is relatively inexpensive for a small entity. The filing fee is $150. You can get a book called Patent Pending in 24 Hours from Nello Press, which is about $40, and it'll show you how to do it yourself, okay? I recommend working with a patent attorney. So that means you're more likely to have enough stuff in the provisional to at least support some claims, right? To support some understanding of the patent. And working with a patent attorney, you know, for me, for a company that's in the process of raising their first angel investment, this comes in on a fixed budget of something like $2,500. Okay, so $2,500 to get your provisional application filed, and that includes me giving you an outline, a set of claims, maybe some block diagrams, and doing the filing and the filing fee. That's the total fee, the total cost, right? So that price is meant to be able to make it so you can bootstrap, so you can get your IP filed right before the funding rounds. That gives you 1 year, okay? 1 year to raise money and then pay for a full patent, non-provisional patent application. So a non-provisional application, typically $18,000, 18 to 20 maybe. And that's really expensive because it's basically the expensive patent attorney writing the whole document, a 30 to 40 page document, right? And filing and the filing fees and so on, right? Which are higher. After you get your application on file, the patent office almost always, they'll wait a year or two and then they'll reject it. And they'll give you reasons for telling you why your application, 95% of the time, application is rejected on the first round. Your patent attorney then has to go back to the patent office and say, no, patent office, you're wrong. This is why you're wrong, and write a document, or an office action response, it's called, either arguing that the patent office is wrong or changing your claims in order to narrow the scope of what you're asking for. Typically that happens 2 times over a patent, and there it's like 5,000 a piece. So I put 30 grand. By the time your first patent issues, you know, 4 years after your provisional filing, you probably spent $30,000 on it. And of course, these are ballpark figures. I have had patents where, you know, I have some clients where the engineers are wonderful writers, and they do most of the drafting on their own, and their cost structure is completely different, right? It's much lower. Yeah. We talked a little bit before about patent families. So the if you file a first application and then you file a second one with further improvements, we reuse all of that first material and we just add another 5 or 10 pages. Okay, so that really reduces the cost. I have looked at clients of mine that have done a dozen or a couple of dozen patent applications and looked at what their average cost to get the application on file was, and that drops to about $9,000 to $12,000. Okay, those are real numbers. So the first one's more expensive. There are people that will do patent applications for a lot much less. We call it, high volume people, right? So if you are a large company that is filing 500 patent applications a year, you don't want to spend, you want to minimize that cost, right? Because you have so many, you have quantity, right? If somebody is going to infringe on your products, there's going to be 3 dozen patents that infringe on it, okay? If you're an early stage startup and you're going to be looking at your A round or doing your exit with 4 or 5 issued patents and 5 pending applications, you want those to be really high quality. So spending money on patent applications is like buying a car. You can buy a Yugo for a few $1,000s. I don't know if they sell those anymore. You can buy a Camry, okay, which is going to get you 400,000 miles and do really well. You can pay a lot of money. You can buy you can go to some big, huge, expensive law firm, buy a Jaguar, which is probably going to spend half its life in the shop, and make some attorney really rich. You want to balance this. If I have a startup and they are pitching money, let's say it's a software company with a new iPhone app, I'll tell them that their first year after raising money, after their first $500,000 to $1 million, a patent budget could be $35,000 to $50,000 for all their IP. Okay, and that's a nice number. Investors should be happy with. It could change, right? But that's going to get them a few patent applications on file and get their trademarks started, things like that. Right. So if you're budgeting a startup after funding, that's the amount of money you could expect to spend. It really depends a lot about how aggressive you want to be. Okay, so I've gone on for almost an hour now. I am going to go and look. Let me bring my last slide up here. I'm going to go now and go through the Q&A tab. That's the questions and answer tab. And I'm going to try to answer any questions people have brought up. If we have time, I will then go to the chat and see what's there. But if you have direct questions on what I've talked about, please put them in the Q&A tab, which now has 5 questions in it. So let's bring that over to my center screen here. Okay, so Jim F asks, how early in the invention process should I file a patent application? Pretty early. Certainly before you talk about it. So one thing I didn't mention is that in the US, if you make a public disclosure, and that could be a presentation at a pitch event or anything where anybody can come, right? Or a seminar at a university, that is, you have 1 year in the US to file your patent applications. But in the rest of the world, there's no grace period. So you want to file first, okay? So before you're going to do anything public, file your first provisional application, right? So do file early and get the, and that's a case of where you might file something that's a relatively thin provisional, and then 4 months later, as you've invented more and your development has gone further, you probably will have a whole lot more material. You take that original provisional application, add 10 more pages to it, and file it again, right? So now by the time the year is up, you might have 3 or 4 provisional applications you filed, and you wrap them all into one big non-provisional application. Saves a lot of money, right? You'll see that process of doing provisionals is relatively easy and painless. So it's something that you should consider doing on a regular basis as you're raising money. Once you raise the money, then you try to spend more money on the patent application, all right? So Jim is asking about using code snippets produced by generative AI websites, which gets the code from scraping it on the web. Yeah. So you're going to want to talk to even you're going to want to talk to a copyright specialist, right? Especially imagine this situation. I'm going to give you two situations here. You're pitching the company to an investor, right? And they've agreed to put $1 million into your company for 20%, $5 million valuation, good, right? And they're about to close the deal, and the investor says, have you talked to an attorney about copyright issues when you grab your code snippets? And you say, no, not really, but we're not worried about it. We will. That investor is going to go, huh, wait. You need to be prepared and be able to answer that question when you're when the investor is doing due diligence on you. So, and again, it's going to depend a lot on what the size of the snippet is. If it's just a cookie, that's different than if it's 5 lines of code that's pretty unique, right? So go and definitely talk to a copyright attorney. Then when that investor asks you a question, you can say, yes, so-and-so is our copyright attorney. This is what their analysis is. We're good for that. We've taken care of the problem. And then you look really good to the investor. Yes, these people are on top of it, okay? Of course, the next step is 5 years later, you're using these code snippets in some way, and the original source of them, whether it's auto-generated or however it's produced, they figure it out what you're doing, and then they come after you, and it's going to kill your company, right? It's a lawsuit in the $50 million range, and you're dead. So get that taken care of. That's the type of thing where attorneys are useful, right? Figure out exactly what your risk is so that you can handle it right now with investors, and later if actually something develops, okay? And they might be able to give you suggestions on how to reduce your risk, right? A smart attorney is going to do that. Okay. Somebody's asking, can you patent an organizational structure? Probably not. But you'd have to sit down with a patent attorney to really find out. You could patent flow of information that's unique, perhaps. Patenting business methods is really hard. It is possible, but it's quite hard. So a new way of doing business. Examples of things that aren't patentable are just stuff that's pure algorithms. So calculating the risk on an option or on an insurance product, not patentable, okay? Software that's calculating deceleration in anti-lock brakes is patentable, right? So the more physical result you produce, okay, the more technical effect that you have. In Europe, the standard is to have a technical effect. And that could be sorting data, processing an image, lots of technical outcomes. If you produce a technical effect, then your chances of getting a patent in the US or anywhere else really is much higher than if there's no real technical outcome, okay? So that's a good one. You can't patent laws of nature, pre-existing stuff. You could patent something that's purified, right? So you could take something found in nature and purify it in a certain way, and that process might be patentable and the final result might be patentable. Again, this is specific case-by-case structure. Okay, and Anonymous is going to ask, I'm a founder, solar entrepreneur, is planning to move to Florida this January for many months and to Europe or Israel. Any special considerations we should make we go about filing trademarks and patents in upcoming weeks and months? Would the attorney we hire have to have a certain kind of experience or background to facilitate calls and paperwork for citizens who's relocated? No, you're going to be okay. A U.S. patent attorney, if you're a U.S. citizen, a U.S. patent attorney, I'll be able to help you with everything. There's going to be some issues where you invent something in Israel and you want to export it from Israel to the US, but that's not going to happen right away. And some countries, including the US, require export licenses for technology. So sometimes we'll have an issue where we have a US inventor and a French inventor, and you actually have to apply for a license in France if you're going to file in the US first, but it's a quick and 3-day process. So your patent attorney will work with you on that, but I represent US and non-citizens all over the world. I do the filings in the US first, but that's it's on some occasion I'll refer them. If I have a German company that's all Germany, I'll refer it to my German associate who's really good. So it's easier just to process that way. Jim F asks, are trade secrets risky with the first to file system? Can the company who obtains a patent on your trade secret sue you for infringement? So what Jim is saying is, if I keep something trade secret and then somebody else patents it, can they sue me? And the answer is yes, they can sue you, but you have a really good defense because you've kept really good notes and you have records. And your response is, we've been doing this for 15 years. So go away, your patent is invalid, okay? And I've seen cases like that. I remember a client that was doing a material processing for metals, okay, and making a really hard metal that worked really well. And they got a patent and they went around and showed this off. And Ferrari came to them and said, we've been doing this for 25 years. We use it in our gearbox and we do virtually exactly the same thing that you've got in your patent now. And so by patent, that patent died. And Ferrari had been using it as a trade secret. They weren't revealing. So if you have a trade secret, the danger is somebody else will come up with the idea and they can go ahead and use it, right? If a trade secret's developed independently, they have the rights to practice it. Okay, so so that's a big part of deciding if you want to make something a trade secret or if you want to make something a patent. Okay, let's see. Hold on. Next question, anonymous. A college research team has developed a product to aid in research. The product will be developed solely for academic work. However, the product has the potential to end up as a valuable asset to the market and a threat to competitors in the market. How does IP work in this situation? Sorry if I don't understand me. My English is not my mother tongue. Your English is great. So this is pretty common. My first patents, I have a few dozen, were university patents. And in the US, there's a law, Evans-Dole, Dole-Evans, whatever. There's a law that establishes the rights of universities to own IP. And so the first thing to do is go and talk to the university. If it's a US university, they probably have a technology transfer office, which may be, different universities are good, some are not good, right? Some are no business sense and some are professional and are really good. I mean, there are tech transfer, like Stanford University makes huge amounts of money from their tech transfer office, and they're really good at working with companies, right? If a professor or an external entity wants to license technology, I think that right now I can name at least 3 clients where their original IP came from a university. And there's a license agreement back to the university, exclusive license agreement. So yeah, this is common. Usually when you go work for a university, whether you're a student or a professor or a postdoc or whatever, or staff member, you sign an agreement that has an IP clause in it. Okay, so if you have something coming out of a university that's coming out of academic work, you need to consider like who really contributed. Was it a whole research group? Okay, so you might have a bunch of inventors, and you need to talk to the university directly. You can contact a patent attorney and help with that discussion, but it's pretty common. Okay. Ruby is asking, how specific does a provisional application need to be? The more specific, the better. Okay, so when I work with somebody developing a provisional, I write a set of claims and then use those claims as an outline so that we know, every item in the claims that we think we might get in a year from now, right? Or file a year from now. Every item in those claims, we make sure that there's a paragraph written about it somewhere in the specification. So we've got enough detail there to support those claims. That really helps. The more you can put in, the better. And it's you go to some software developer and you say to them, I want you to write 20 to 30 pages. you kind of get sometimes a blank look. What? I haven't written a paper since I was a freshman in college, right? So yeah, it's working with an attorney who's used to startups and kind of hand-holding through that process is real big help. But the more detailed, the better, right? The more meaty. If it's just a PowerPoint deck of your pitch, you might have filed that as a provisional so that your presentation, you have a filing date before your presentation, which protects your rights in places like Europe or Korea. But that's not going to be a very useful provisional filing to support later non-provisional, right? You got to remember, if you file that 2 months later, file something more with much more meat to it, okay? Stephen asks, what did my, oops. I don't know, did you lose? I think I might have lost you. Hold on, guys. It says I'm sharing screen, but I rolled. Okay. I'm going to stop share. There we go. Okay. Stephen Williams is asking, I have a large number of ideas that are used together to create a larger system. Is there a clear or simple rule for when the USPTO will force them to be separate patents? It's going to be on a case-by-case basis. You'll probably have a patent claims that cover the entire system, and then you'll have patent claims that cover each different element, right? And so your strategy might be, depending on the technology, your patent attorney might say, okay, let's start covering these 3 elements first, and then we'll go for the whole system, see what we find, or the other way around. And again, you can put all this into a patent specification into the document. You might have a document that's later going to be used in 5 different patent applications, right? And what's going to be different about it is that you're going to have different sets of claims. Go and come to one of my seminars on how to understand a patent, and I'll explain much more detail how this works. But you can have a document that has different claims that focus on different aspects of that document. In your case, a set of claims that look at the whole system, and then a set of applications that appear in the sorry, folks. Yeah, that's the answer there. Okay, Anonymous is asking, what are the pros and cons of filing 10, 20, 30 trademarks versus one in one go versus 1 to few filings, then another few? I was concerned if we filed too many at once that we receive better pricing from the lawyer, but the result in lower quality. So the first thing you want to do with trademarks is use them and put a little TM, right, with a little TM symbol next to them. And that gives you initial rights. Okay, so trademarks as an early stage startup, by using the TM, write down the date you first used it. Okay, most countries in the world are first to use for trademark, except China, right? So go ahead and use your marks, right? If you have a whole lot, sit down with the trademark attorney and say, this is our package, and ask for a discount, right? A lot of the trademark attorneys I work with have a fixed fee, right? They do a trademark for a flat fee. And so if the description of the mark is going to be the same across a bunch of applications, that really is going to save a lot of money, right? But if the different marks are used in slightly different ways, then it's not as flexible in terms of giving a discount. Okay, but again, talk to and I'd be happy to refer you to trademark attorneys. Okay, so Mike's again asking how detailed should a provisional application be? The more the better. Okay, I call it the Starship Transporter application, where somebody describes all the advantages and description of the Enterprise transporter, but doesn't give any details of how the technology works, which is kind of important, Okay, in that case, that's pretty worthless. Okay, you get sparkly things, and Captain Kirk disappears from the platform and appears over here in a planet right on the surface without falling or anything. That's pretty cool. Great marketing description of that product, but you need to have the technical details of how to implement it. Preferably, the provisional patent application should fully support the claims that you're going to have in a later non-provisional. And it should explain, right? The standard is you got to give enough detail for somebody in the field to go and reproduce the technology, right? You have to teach them how to do it. You can't hide critical things like how the sparklies make Captain Kirk move through space, right? Regarding taking notes, Anonymous is asking, I've written all my notes from meetings online and in person in one email draft per meeting. Yep, with a subject line and the meetings. I never publish email myself the notes, so thousands of drafts sitting in my Gmail box. Are the notes taken in this manner still able? I would send them. So this has actually come useful to me. I have an email account, and you can use Gmail or Yahoo or Proton Mail, a secure email service, and you have an email. I'm not going to tell you what the email address, but I have an email account where I use as my filing system. So if I file my taxes, I take that PDF and I send it with a nice header, and I send it to that email account, and I log into it every. Yahoo now, if you don't log in for 6 months or something, they'll wipe the account. You have to be careful. Okay, but I send an email to one of those accounts, and that is. I don't leave it as a draft. I actually send it somewhere. The point, I mean, I suppose having drafts in your box with the proper date, and it depends on exactly how Gmail or whatever you're using works. You want to be able to show, if you touch a draft, if you try to read it, is that going to update the date? Yeah, that could be a problem. So yeah, I would actually send it. I build an archive account for you. If it's my child's report card, it goes to my archive file, right? So that's what I do. That's useful. And then for notes online, where I'm not really worried about date stamping, I use OneNote, Microsoft's OneNote, and that's really helpful. And then I use Word and I put it into the client's folders. Right. So Anonymous says, I ask about how IP works in college research in a situation where the college has no documentation on IPs for students. We'd have to talk in detail about that. It would be unusual for a university, certainly a US university, to not have some IP documentation. If you're outside the US, it's going to be a matter of the local country's laws, right? But you'd have to ask me in particular for a specific university. If it's like a junior college, I suppose in the US, they might not have an IP clause, but still you need to check just to make sure. And have your patent attorney discuss it. And then the invention is the property of the inventors, right? And if, let's say you have a patent that has 30 claims in it, and one inventor just did one little bit of the 29th claim, right? And the other guy did everything else. In views of the patent, they're equal, right? So all somebody has to do is contribute to the conception of one idea in the claims, and they're considered an inventor on a patent. So you got to be careful with that. That's another thing that a patent attorney can sit down with you and say, okay, who's an inventor and who's not? My brother-in-law came up with this idea. Oh, I do an assignment document from him, blah, blah. Okay, that's it. Okay, so I think we're through the questions, and I'm bringing the chat up. Chat. Okay. Okay, I'm going to go through this really quickly because we're going, welcome. That was me. Somebody from Norway. Somebody in California is asking, are we supposed to disclose that PR we are working on during non-business hours while having a full-time job? It depends on the company. It depends on how related the IP is to the company's business, and it depends on the company's IP policy. So this is very specifically a case-by-case thing where you have to have an attorney look at all the documents, right? If it's something not related to your employer, I'm not too worried about it. Again, if you're doing a lawnmower and the company is a web development company, I'm not worried about it until it becomes a web controllable self-driving lawnmower, right? Okay. All right. Is this being recorded? Yes, this is recording, and within a week, we'll send out a link for the recording. A college research team is developed product. Okay, I think we answered this one. Okay, how would somebody protect a web program application idea, especially where there's no patent? So about 70 to 80% of what I do is software. A lot of them are iPhones apps and web products and things like that. So there's certainly patentable subject matter. So filing the provisional patent application is the best way to get some initial protection on that. An NDA helps. If you have an NDA and you're talking with somebody, as long as you're not actually offering your product for sale, that will make it a non-public communication. Sometimes it's hard to get an NDA in place. Big companies don't want to sign them. Certainly investors won't want to sign them because they just see too many companies. It's impossible. Is there any reference book I would recommend? A Patent Pending in 24 Hours by Nolo Press is good if you want to do, that means 24 hours of your time and work. If you want to try to do a patent application completely on your own, but I would recommend seeking the help of a patent attorney. It's worth it. What's the source link for filing a patent? In the United States, it's uspto.gov. Okay, somebody's asking if their patent contains both copyright and trademark. So patents, copyrights, and trademarks are different things, right? So something covered by a copyright, for example, code could also be patentable, but let me give an example. If I write a program in C++ and I write it in Python, those might be different copyrights, but they might be both covered because if the functionality is the same, they can be both covered by one patent, right? So the patent you look at is covering the whole functionality. The copyright is the specific implementation. Yeah, so software patents, I do a lot of them, and they are enforceable in a big way. So yeah, you can file software patent applications and get patents on software. The key is there has to be some really good technical effect, right? And that could be development of a composite image, right? Or video game content, how to insert an ad onto the back of a player. I mean, this is old, right? But this is the type of stuff I've done patents on. Remote rendering technology for video games, virtual keyboards, blockchain, advertising management, processing ultrasound for medical use. These are all kinds of software things that I've done, lots of stuff lately. Okay, I'm going on to anonymous. Okay, that's it. How does software company, okay. How about an idea for a disruptive startup that can transform the way an industry works? Yeah, be sure to cover it in patent applications. Okay. I did discuss trade secrets a little bit. The most important thing there is to document them. And then when you're talking with your patent attorney, you have a conscious decision of what things you're keeping trade secret and what things you want to put as patents, right? And you'll have lists of both. Okay, put a trade secret program in place, and that makes the trade secrets actually much more tangible and much more valuable. Okay, great to see. I mean, thanks, Brian. You're an angel investor. Good. Yes, connect with Brian. Okay, moving on. Okay. Okay, so when you're talking about notes, where do you store notes that proves the dates? So I send it to, I used to have a Yahoo account, now I have something else. I would send it to my Yahoo account, and be able to then go to that account, see the email, and point to somebody and say, look, this is documentation. And I've done that actually recently for something that I emailed in 2004. Okay. So yeah, so you can then look at the email that's stored on the Yahoo account and say, okay, this is what this person wrote on this date. Here's the text, and that's good evidence of invention. Okay, so yeah, the receipt date on a where you aren't, when it's not your own email server, whether it's Yahoo, Gmail, or Proton Mail or something like that, that's good evidence. The very first time I had to do something like this, it was actually on a backup disks for a university hardware, computer servers. And this was in the early 90s, right? So it wasn't web. It was like, okay, here the university was doing backup disks on a weekly basis of their servers. And those disks had code on them that I could show, and that made a difference in a licensing deal, which was very important. Okay. Oh, we see and hear you. Okay. Oh, somebody was inaudible. Okay, that was, I'm sorry. What is a recommended structure of the claims in order to cover as much as possible? You want a diverse set of claims, some broad, some really narrow. Okay, not just big broad. Something I want to say here, I have just a couple of minutes left. In order to infringe a claim, somebody has to do every element of the claim. And this is one of my pet peeves. People will come to me and say, I got this wonderful patent. It only cost me a few $1,000s. This guy in Chicago did it for me. It was really inexpensive. And I look at the first claim, and he got it right through the patent office. It has everything I do in it. And I look at the claim one, and it really does have everything he did. It's like a page and a half. Okay, that means that it was easy to get because it was so narrow. Somebody would have to do everything in that claim in order to infringe it. Everything. So if they're missing one element, they're not infringing. So a claim that's big is really narrow. A claim that's only 3 lines and right to the point is really broad. Okay, so keep that in mind. Don't be fooled by this, oh, I'll get you a patent, and then you'll have some patent agent or somebody who'll do a really lousy job. They won't understand. They'll save the trouble of having to fight with the patent office just by making your claim incredibly narrow, and the inventor won't understand that what he's got is extremely narrow and really pretty worthless. And I see that often enough that it's a really pain in the butt. Okay. I talked about trade secrets. Document. Keep control. Don't let everybody see it. You got to have a program in place. Can somebody sell my emails to other people? I don't know. Who would buy it? I wish I could get, yeah. I sometimes wish I could get paid per email I delete. You know, if every time I delete an email, I got $1. Okay, that's it, folks. Okay, wait, going. I am cutting this off in 6 minutes, right? What are the key questions to ask when going to hire an IP attorney? Budget. Always with attorneys, right? You know, if you're being tried for murder, you don't really care. But if it's an IP attorney or a corporate attorney or a trademark attorney or the attorney who's doing your founder's agreement for you, get a budget, get cost estimates, right? And this helps both parties, right? The way, you know, if I give a bill to a client that they weren't expecting, that's a real pain in the butt for both of us, okay? So I'm lucky that I'm in an area of law, patent prosecution, where it's really easy to predict how much time I'm going to spend. So I can give flat fees, like $2,500 budget for a provisional, right? Sometimes I'll spend a lot more hours than I'd planned, but sometimes less. And I'm helping a startup, so it doesn't really bother me too much. But like patent litigation is a really expensive, it's hard to tell. Is the other side going to cave right away? Or are you going to spend, I have a patent litigation project, I have one right now, that is going to be 6 years old in a couple of days, right? Millions of dollars in budget. And it could have been that it was settled in the first 8 months, right? And it would have cost 40,000. So that's really hard to predict how much the budget's going to be. But for patent prosecution, where you're trying to get patents, that should be predictable. If nothing else, a patent attorney should be able to give you a cap. It won't be more than this, okay? Other questions to ask, make sure they have some understanding of your technology, right? So I do pretty much everything. My PhD is in analytical chemistry, which is the science of chemistry to build of instrument building. And this was in the days of PCs, IBM PCs, before the XT, okay? So I'm really good at electronics. We used to build our own boards, data acquisition electronics, lasers, optics, lots of software because we had to write, assembly software from scratch. I stopped writing software in about 2000 at C, and I was doing C++ at the time. I was doing web development as part of being a CTO. In the 90s, I had a popular scientific instrument website, which was great. So I don't do pharma, right? So I have a partner. Ramon is getting about 185 attorneys. We do everything pretty much. I have a guy who's got a PhD in biochemistry who does pharmacology, right? He'll do drugs, lucky guy, right? He'll do the DNA, RNA, antiviral programs, all this type of stuff, right? So if you are in a specialty area, look for a patent attorney who has at least some understanding of that. I do lots of software, lots of apps, plenty of blockchain, plenty of health tech is really big. Yeah, pretty much. So you'll talk with a couple of patent attorneys and see which one really gets what you're doing, gets your company. That'll make a difference, right? Hopefully, your relationship with your blockchain, your patent attorney is going to last until acquisition of this startup, and then through the next 2 or 3, right? I have clients that I've had for over 20 years that are in their 4th or 5th company, and it's really fantastic, right? Okay. Thanks so much. Thanks so much. Okay, guys, that's it. There will be an email coming out within a week with the slides and recording, and that's it. Please, I want to finally thank Rob and Idea.IPO for putting this on. We enjoy it very much. I will actually be hosting a panel later this week, VC investment panel. So look out for that. Thank you very much. Have a great day.